NACDL is the association of the nation's criminal defense bar.
Executing a cross-examination in a sex abuse case really boils down to one thing: preparation. The more prepared you are, the better your execution will be. So today we're going to spend a lot of time talking about execution, but we're also going to talk about preparation, preparing to execute. And essentially, if you tune me out for the next 50 minutes, just remember three things. First, watch To Kill a Mockingbird. If you have not seen To Kill a Mockingbird, watch it tonight before you get lit up. It is a fantastic movie. It is amazing, and it tells you just how difficult it has been to handle sex abuse cases from the defense side since the beginning of time, and it really is a great movie. Number two, buy Posner and Dodd's book on cross-examination. It has nothing to, it's not specifically geared towards sex cases, but it is the Bible when it comes to cross-examination. It goes through every permeation, every different type of cross you can imagine. I highly recommend it. I have absolutely no financial stake in it, so I do recommend that you buy that book. And number three, the most important thing I will say today is listen to old school hip hop. Specifically listen to Shaggy, It Wasn't Me. If you listen to Shaggy, It Wasn't Me, it will motivate you before your next sex abuse trial. Those are you can tune me out for the next 40 minutes or so. The order of our presentation, and this is actually secondary to all the three things I just told you, we're going to talk in general about jury instructions, investigation, motions that impact cross-examination, the chapter method of cross-examination, and specific types of crosses, like when witnesses cry, when you have a runaway witness, and we'll end with a very general conclusion. Any questions at all? I don't mean to stand in front of you and bark for the next 40 minutes. If some of you disagree with what I say, or you have different experiences, or you have questions, please let me know. A few things I'm gonna say I baked in here knowing that there's gonna be some disagreement. So I encourage you to let me know if you disagree and we can have a discussion about it. Starting with the first thing we're going to discuss, jury instructions. It doesn't matter whether you've been practicing for 30 years, 3 years, 3 months. The very first thing that you should do when you pick up a case is pull the applicable jury instructions. Day one. When I was a public defender and I was practicing in the same courthouse, in the same jurisdiction, it's easy to fall into the trap thinking, well, look, this is all I do. I'm a criminal lawyer in this jurisdiction. I know the law. Trust me, you will forget an element. So day one, pull your jury instructions. When I went into private practice, it was even more difficult for me because I was bouncing between different jurisdictions and the law vastly changes. So if you're in private practice and you're handling cases across jurisdictions, this is incredibly important because the law changes depending on where you are. For example, if you're thinking that you're going to be cross-examining the witness on consent because your theory of the case is consent, that may differ if you're in DC or in Maryland. The jury instruction in DC discusses proving consent by a preponderance of the evidence. So in DC, your cross-examination may be focused on consent. But if you're in the neighboring jurisdiction in Maryland and you have a case where the government's theory is that the complaining witness was incredibly drunk, she was at a bar, and your client says it was consensual, you're probably not going to focus your cross-examination on consent because the jury instruction in Maryland says if the person were substantially cognitively impaired, i.e. shit-faced drunk, then consent is not even a defense. So you're going to spend your time investigating and cross-examining on whether or not the witness was substantially cognitively impaired as opposed to whether there was consent. So all that to say, day one, pull the jury instructions, day one. When you're investigating the case, so jury instructions will help guide your investigation, but there is a difference of opinion as to how you conduct an investigation, specifically in a sex case. Do you investigate all of the potential theories? The most common theories I've laid out for you here: consent, which is a variation of fabrication; misidentification, otherwise, it may have happened, but it wasn't me. I don't know who it was. Number 3, fabrication. It just didn't happen. She's flat out lying. A fourth, and less common, but it is becoming more common in today's day and age, is that the statute of limitations has run. This happened way too long ago. That's actually not a defense in some jurisdictions, so make sure you look at the law before you pursue that defense. When I was at PDS, when I was a public defender, we investigated all potential theories. And the reason was, well, one, it's unclear whether your client trusts you. So it's unclear whether that person is telling you the truth on day one, because he may not know you well enough to trust you. Therefore, he may lie and say, wasn't me. I don't know anything about this. I don't know. This is a misidentification case. But it may evolve where your client develops trust for you a month later, 2 months later, he trusts you more, and he says, all right, actually, this is what really happened. And that was not uncommon for me in my role as a public defender. And so in that role, I investigated every potential theory. Also, we had the resources to do so. So many of you may say we investigate all theories because that's the way to practice. In private practice, I will tell you that it has been a bit different. And when a client pays you on day one and tells you, I'm giving you X amount of money, this is what happened. I want you to go out and investigate this particular theory of consent. And you spend your time investigating mis-ID, and you're billing the client $300 an hour, however much an hour to investigate, you're gonna have a problem with your client. So I don't know what fits your practice, but understand that there is a difference of opinion as to whether or not you should investigate all potential theories of the case. When you're conducting your investigation, this sounds basic, but interview the complaining witness, or at least try to. What I've heard from lots of practitioners, specifically in private practice, is, well, she was raped. She's not going to talk to us anyway. I'm not going to spend time and effort and money trying to track this person down. She's not going to talk. Let's assume there's some truth to that, which is a big assumption. Even if you try to interview the complainant and fail, you're preparing for cross-examination, because you're learning this witness's demeanor. How she rejects you, how she says, I'm not going to talk to you, tells you what type of cross-examination you need to prepare for. If she slams the door in your face and curses you out before saying no, that tells you one thing. You may have a runaway witness. You may have an angry witness. If she breaks down in tears and says, I just can't talk about this, then you're going to know that you have a crying witness that you need to prepare for. And so even if you don't substantively gain any information from attempting to interview a complaining witness, I strongly encourage you to do so to prepare for your cross-examination. Social media. These days, I don't exactly understand why, but people put everything on social media. It is almost malpractice not to start investigating a complaining witness via his or her social media on day one, if nothing else for the reason that she may delete posts as the case moves on. I've seen it happen. So you need to get those posts quickly, preserve them to start preparing for your cross-examination on day one. And if you're anything like me, you're gonna have to consult. I've got to talk to my nieces about what types of social media is out there these days. Twitter, Facebook, Instagram. I guess there's something called TikTok, which I've actually never heard of, but she told me to put that in this presentation. Look at this information from day one. It will help you develop a timeline. For example, I had a sex abuse case where the complaining witness, was literally posting at the comedy club, ha, 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 ha. Now, on our way to the hotel, ha, 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 ha. At the club, photo, popping bottles, photo. So, and this gave me a timeline that this witness had been drinking since 6 p.m., which was important to the case. So I say that to say, start investigating social media from day one. It could help you find timelines. It could also help you find impeachment witnesses. And so people post on Facebook, and then there are people that post underneath and all these comments. And It was a blast. We had a ball, or that was a great night. Where did you disappear to? All of these things were underneath of a particular photograph that was important. So the photograph was about popping bottles in my case. Then a witness said, where did you disappear from? So we actually interviewed that witness. And on cross-examination, part of the cross-examination was, you were with X. You were with Fahima Downs. No. You were popping bottles with Fahima Downs. Nope. Now, fast forward through all the problems we had during the cross, we actually called the impeachment witness later to complete the impeachment. So I say this to say, investigating social media early can help you with your cross in terms of completing an impeachment as well. So start your social media investigation early. It will help you prepare for your cross-examination and save you lots of headaches later. Caution. If you find a witness that has a private page, stop. I have, especially in private practice, some of the investigators are incredibly aggressive, which is great. But some of them want to create fake pages and then friend the witness with a private page. Most jurisdictions that I've heard of, Maryland being one of them, and most of them say that is not ethical. Even if it's not you, if it's your investigator creating a fake page, then friending a witness, that can be unethical. So I know I've just barked at you for 3 minutes about social media investigation, but resist the urge to be a bit overly aggressive and create a fake page through an investigator because it can get you in ethical trouble. Another potential ethical problem is whether or not you can friend an unrepresented person. And so when I had this issue come up, I actually didn't know the answer. I couldn't find the answer, and I actually didn't trust my own research anyway. So I picked up the phone and just called the ethics hotline, which they have many of them in various jurisdictions. In Maryland, I just picked up the phone and asked the question. It took a while, but I got an answer. The point is, proceed with caution if you have a witness that has a private social media page, because there are ethical implications that can arise if you try to friend that person. So now we've gone through pulling the jury instructions, investigations. Now we're at the motion stage. So what types of motions can you file, and should you be thinking about filing in preparing your cross-examination? One of the motions that I found to be actually very creative, and it was the competency motion that was filed in the Bill Cosby case. This motion is probably, we put it in your materials as well, so you actually have a copy of it if you want to take a look at it. It's much more important in today's day and age where we have more cases arising from 10 years ago and 20 years ago. When you have those cases, you may want to start thinking about filing this motion early. And it's going to require you to consult an expert witness that is not dissimilar from a misidentification expert. So you have to start thinking of this from day one, consulting the expert, the psychology expert, and determining whether or not you have a strong motion to argue, well, the witness, there's no indication that the witness properly stored the information in his or her brain and then is able to accurately recall the information. It is a very strong motion to flesh out the government's theory as to how this particular witness claims she's able to believe or remember something from 20 years ago, all the details. Even if you don't win the motion, I encourage you to consider filing the motion so that you can smoke out some of the government's case. If you have found in your investigation evidence of other sexual activity involving the complainant, stop and think about filing a motion to admit this evidence. It may be juicy for your case, it may be helpful for your case, but if you don't file a motion, it is likely that you will not be able to use this evidence at all during cross-examination. The rape shield law is strong and it is procedurally prohibitive. If you do not do it in federal court at least 14 days prior to trial, you will be procedurally barred from introducing this type of evidence in your case or during cross-examination at all, or in your case in chief. So if your investigation uncovers it, stop. Think about filing a motion under Rule 412. Most states, I can't think of a state that doesn't have a state analog to this rape shield law. Every state that I've come in contact with has an analog. So think about filing this motion. There's usually some variation of you can admit evidence, or you can argue to admit evidence that is probative of the source of injury of the complainant. Someone else is the source of injury or the source of semen. So some other sexual escapade resulted in injuries or semen. Or, well, there was prior sexual activity between the complainant and our client, and therefore it's indicative of consent. That's the second category. The third category is the catch-all if the Constitution requires it, which is usually some variation of the Confrontation Clause. But that's what I've seen, and that's certainly the federal law. In most states, it's some variation of those three. The takeaway is, before you conduct your investigation, file this motion, or you will just be barred from using the evidence in total. Counseling records, extremely difficult to obtain. There's a case, Pennsylvania v. Ritchie, which is sort of the seminal case, or it is a starting point, but it is about as clear as mud, and different states interpret it differently. Some states say, well, under Pennsylvania v. Ritchie, you are at least entitled to an in-camera review of some of the records, right? Some states say, no, that's not what the holding says. The holding is limited to whether or not information about counseling is in the possession of a different state agency, and therefore the state is required to disclose it under Brady because it's a subset of Brady. Even though it's not physically in the custody of the prosecutor, it is in the custody of a different state agency and therefore discoverable. Different states have interpreted this case differently. The point is, if you have an issue where you have found that a witness has undergone psychological counseling related to alleged sex abuse, this is a good starting point, and you're likely going to need to file a motion to access those records. So don't think that you're just going to issue the subpoena and the subpoena will come back. Usually it will not. So now we get to the cross-examination itself. This is where, in sex abuse cases, drug cases, murder cases, it doesn't matter. I strongly encourage you to follow the chapter method of cross-examination. We could have an entire lecture. We could talk for the next hour about the chapter method because it applies in every single type of case. A very short synopsis of the chapter method. A chapter is one discrete point that supports your theory. We already talked about the common theories, right? The chapter method is asking a bunch of questions, a series of questions, to establish your chapter. What I do, the last point on this slide, is at the very beginning of a case, and I start creating a running list of chapters that I want to elicit from the complaining witness. And I just add to it as the case moves along. And as I get closer to trial, I refine the list. It helps me think about how the cross-examination will proceed and whether or not I need to conduct an additional investigation. So from day one, start thinking about the points that you want to make, list them out in some Word document, and this will form the basis for your cross-examination later on. Practice tip. Every different chapter should likely be on a different, not likely, it should be on a different page. I would not encourage you to just have all of your questions in a row. I'm just going page to page to page to page to page. List out a chapter and have all those questions on one page, and then the next page is a completely different chapter. Why? Because at some point, you're gonna need to rearrange your chapters. You're gonna be sitting at counsel table, something is going to happen on direct that you did not anticipate, and you're gonna need to say, you know what? I need to rearrange this chapter. For example, the witness starts crying, and you need to force the witness to use her eyes for looking at a document. We'll talk about that in a minute. But you may need to the point is you need to rearrange your chapters mid-trial. You can't do that if all of your questions are just listed out from beginning till end on just one running document. So we talked about chapters. What are concrete examples? What do I mean? Well, in fabrication cases, specifically consent cases, or fabrication in general, people say that motive is not required, which is not. There's no jury instruction requiring you to prove motive. Doesn't exist. There's no affirmative obligation for you to prove motive by a preponderance. It's not an element of the offense that the government has to prove. So it's not actually at issue. But as a practical matter, it is required. If you're saying that the complaining witness is lying, then the jury is going to want to know why. Why would a complainant lie about something so serious, and especially in today's day and age? And so although it's not required of you, I strongly suggest that it is at least one chapter, if not several different chapters of your cross-examination. For example, Ms. Bryant is lying because she expected to be paid for her services. Now, you're not going to ask her that question because she's going to say, no, I'm not lying, and no, I didn't expect to get paid for my services. That's the chapter. That's the point you're trying to prove. And then you're going to ask a series of questions to elicit that point. But that's just one chapter. Another potential chapter in a fabrication case that's similar to what we just described is, well, she's lying because she was not paid for her services. That's a completely different chapter. And another chapter is, well, she's lying because Mr. Collin rudely kicked her out of his room and says, see you later. Right? That's another chapter of cross-examination. So again, I encourage you to think about your cross and structure it in terms of the chapter method of cross. Actually, I don't know any other way to do it. Another caution. Be careful with the timing of the complainant's motivation to lie. Right? So there was, in the case I was describing earlier, there was an allegation that my client, it was a forcible rape. Part of the theory that we were considering pursuing is that after this incident, our client badmouthed the complainant and told all of her friends about the incident and said, he badmouthed her essentially and blew her up in public and made her look like she was something less than honorable. So the problem with that is if we would have pursued that theory, she had already reported the alleged incident to her friend prior to our client blowing her up. So she picked up the phone, she called one of her friends and said, this guy raped me, he threw me over a couch, and X, Y, Z. If we would have gone with the theory of bad-mouthing, it would have opened the door to the prior consistent statement, the prior report of rape, because there is a hearsay exception for prior consistent statements to rebut improper motive or fabrication. So as a practice tip, if you're considering saying that the complaining witness is lying, then be sure that your motive to fabricate arose before any subsequent statements that she made to police officers or to friends or to psychologists or to anyone else corroborating this alleged incident. Because if you do not, then you run the risk of admitting all of this terrible hearsay inadvertently. So we dodged the bullet in large part because my partner saw it coming. I wish I could take credit for it, but I cannot take credit. My partner saw this coming, almost walked into a buzzsaw. Told you Shaggy was coming. In a case where your theory is misidentification, again, wasn't me. This goes back to you needing to have seen and read the jury instruction before conducting your cross-examination, because jury instructions are going to guide you and tell you what types of information you need to elicit so that you can say, look, judge, or look, jury, the jury instruction says that you are to consider the length of time the witness had to observe the person's face. And remember on cross-examination, when she told you that she didn't see his face, and if she did see it, she only saw it for a split second before he told her to close her eyes, or before he covered her face, or before he punched her. So the point is, if you don't know what the jury instructions say, then you're not going to effectively conduct your cross because you're not going to be focusing on everything the jury is going to be required to take into consideration. Length of time, the witness's state of mind. In a Miss ID case, was she afraid? Was she looking at a weapon? Was she crying? Was she scared? These are things that the judge is going to tell the jury that the jury must keep in mind when considering whether or not to credit the witness's identification. If you don't know it, your cross-examination will be all over the place. The accuracy of any prior description, critical in a misidentification case. So you're not only going to be crossing the complainant on any prior descriptions, but you're likely going to be cross-examining other officers, whoever she gave that prior description to. And if you hadn't read this instruction, you wouldn't know that you need to cross-examine the complainant. On day one, she said that the attacker was wearing a gray suit with white pinstripes. On day three, she said that the attacker was wearing a gray suit, no pinstripes, black tie, right? So you need to know what, you need to focus your cross-examination on the things that are mentioned specifically in the jury instruction. One of my favorite movies, hilarious, Hustle and Flow. In a sex trafficking case, I couldn't have this discussion with you without mentioning that these cases are being prosecuted more in federal court these days. And there are a few chapters that are just common that we have to discuss briefly. One of which is in these cases where your client is alleged to have solicited the complaining witness from X country and forced her to come here and perform sex acts. One chapter that is certainly going to come up is all the opportunities that the complaining witness had to leave your client's presence. There were 5. It was a home with 3 exits. He would go to work in the morning, or he would leave and he would go out hanging out with his friends. Quid pro quo. She received money in exchange for her services, so this wasn't something she was forced to do just out of she was doing out of the kindness of her heart, or she was forced to do it. She was actually making money to do this. Social media postings about how happy she was. Remember those photographs of popping bottles? All those photographs show exactly how happy the complainant was prior to the government's involvement, prior to her asking the government for a witness visa. All of these things come up in sex trafficking cases that are much more commonly prosecuted today than they were 6 or 7 years ago. So now we're going to talk about specific techniques to use on cross-examination. I started here because this is my biggest fear in any case. When a witness just starts crying, I am literally, in my everyday life, I'm a sucker for tears, right? I got a 3-year-old daughter. I am convinced that she knows how to manipulate me right now. She can just start crying, and then when her tears stop, can I have a lollipop, Daddy? So I'm just one of those people that just, tears actually scare me. And so if I can anticipate a crying witness, I'm in better shape. So these are a few techniques that help me prepare for crying witnesses, because the last thing you want is to be in the heat of the moment and not have thought about how to either stop a witness from crying or to effectively conduct your cross while the witness is hysterically crying. First thing, slow down. Take your time. It's scary. All of us can sometimes be nervous about silence, but the witness is equally as nervous about silence. So if you just slow down, pause, oftentimes it makes the witness nervous enough to just stop the tears and focus on your questioning. So take your time. Another technique is to focus the witness on the unemotional details of an incident. So if you ask the witness, this is a crying witness, before Kobe kissed you, he was standing in the living room. Now you've taken the witness back to the kiss. All she heard was the kiss. She's crying, and the tears are going to keep flowing. But if you focus the witness on things like, Kobe was in the living room. The door was open. He was near the restroom. The restroom was 10 feet away. So instead of loading into your questions the emotionally charged aspects of the incident, take those aspects out of the questions and focus the witness on everything else that is unemotional. And at least you've stopped the bleeding and you've stopped the crying and you've stopped the witness from focusing on the kiss or whatever else happened afterwards. Focus the witness on things like exact dates. Witnesses are always nervous that wily defense attorneys are trying to trip them up. And so you went to the 14th Street Lounge. You went to the 14th Street Lounge on July 2nd, 2018. When you start making the witness think of exact dates, I don't know if it was July 2nd. I know it was early July. It was close to the holiday. I don't know. But it was 4:25 when you first got a phone call from Jason. Yes. The time is another important detail, or another detail that focuses the witness on something other than the incident itself. Distances, measurements, many people are just terrible with how far away something is. Sir, I think that you are 30 feet away, but candidly, I don't know. I don't have a clue. But if you're focusing the witness, if you're asking the witness, when you first saw Kobe that night, he was 30 feet away from you. I don't know. I mean, the witness may or may not know the answer, but what you're doing is you're stopping the bleeding. The witness is now focusing on something other than the tears, other than the incident. Addresses. People can't remember addresses for some reason. You were at the 14th Street Lounge, which is located at 1409 K Street Northwest. I mean, I think so. It's on K Street. I know. But you're stopping the bleeding. Remember earlier when we talked about having all of your cross-examination chapters on different pages? This is why. Because you may need to restructure your cross in the middle of the examination. So now you know that a certain aspect of cross is going to make this witness hysterically cry. You just know that. So you reorder your cross to start with unimportant, unemotional details. Then you got to throw in this emotion that you got to get out. Then again, you bookend it with unemotional details. Right? So the witness is not anticipating the tears. Then the emotional part starts. She cries. And then you focus her again on something unemotional. That's why you need to have your chapters on. That's one of the many reasons you should have your chapters on different pages. When a witness needs to focus on something like a sound, it oftentimes stops them from crying. So if you have a recording, hopefully of the witness, but of something that is unemotional, if your goal is to stop the tears, so you're in direct examination, witness is boo-hoo crying, and you have a recording that you know you're going to need to play, it wasn't your plan to start with this recording, but now you need to do so. Start there and have your witness focus on hearing things, which will then take the witness out of the moment, out of the emotional part of the case, force the witness to focus on sounds. The best sound is usually the sound of the witness's own voice. If it's some impeachment, if it's some inconsistent statement that the witness has made before, whether it's to a police officer, whether you have some recording of it, if you have that, that's the best place I've found to start because it dries up those tears pretty quickly. Making a witness move is another tool that I have found stops the tears for many different reasons, not least of which is the witness is focused on not falling, right? So you say, Your Honor, permission for the witness to step down. Granted, now your witness is, first of all, your witness is not an expert, right? So he or she is not used to standing and walking around a courtroom. So they're inherently nervous. So they're going to be nervous. They're going to be looking down, making sure they don't fall down from the witness stand. Then they're going to walk, and wherever you got, they're not even going to know where to go. You have to tell the witness, I'm going to ask you to come over here and take a look at this demonstrative exhibit that we have marked for identification as Exhibit 3. You recognize this, right? And while the witness is walking, looking at a demonstrative, the witness's tears oftentimes dry up because she is focused on something other than crying, other than the emotional aspect of the case. Get the witness to step down, join you in the well of the court, and I have found that that dries up tears quickly. Making the witness use her eyes. If the witness is crying, but the witness has to start reading a document, reading prior grand jury testimony, reading a prior defense statement that you have, or some other written document that you can find your way to show the witness, that oftentimes stops tears because the witness has to wipe those tears out and actually read whatever it is you're putting in front of her. Even if it's not something you're going to be able to introduce, whether it's a demonstrative exhibit, if it's a photograph or a diagram of the location of the incident, that's another thing that forces the witness to use her eyes, which again, oftentimes stops the tears. Do not use a chronological method of cross-examination if you're anticipating a crying witness. There are very, very few times, and I'm not going to be absolute because I don't speak in absolutes, but I can't think of a time where I have ever used a chronological cross-examination with a complainant. If for no other reason, then they can anticipate where you're going. They know where you're going. If they know that you're going from hour 6 to hour 7, hour 8, they're going to be able to anticipate it and tailor their answers toward your questions. That's reason number one. Reason number two, more related to what we're discussing now, is if there is an emotional moment. The emotional moment is when Kobe started kissing her in the hotel room. If you are leading up to that moment chronologically, the witness is going to start she's going to know it's coming, and the tears will likely start before you've even gotten to the emotional moment. So to avoid the witness anticipating the emotional moment and thereby crying, 5 minutes before you thought the witness was going to cry, to avoid that, do not structure your cross chronologically. Instead, structure your cross based on themes and based on your chapters. What chapter start strong, end strong, primacy and recency, instead of just chronologically. This is what happened when you woke up in the morning, and this is how we got to the hotel. Instead of that, structure it differently. Direct the witness out of the location where this incident occurred. And so you've got a stranger rape case where it occurred in a dark alley. Again, a case that I had, terrible case. And the witness was literally reading a Bible before the incident happened. She was in her home. It's just terrible case. Literally reading the Bible. So in this particular case, I knew that the alley in and of itself was going to make her cry because she told the investigator that she couldn't even talk about the location of the incident. And so I knew that the location was important. Why? Because it was a mis-ID case. And it was a mis-ID case that I needed to say that she did not have an opportunity to view the suspect's face for any meaningful length of time. So therefore, the alley was important. I couldn't avoid it. So in order to avoid the tears or to stop the tears, I tried my best to take her out of the alley. So according to you, this incident happened in an alley. Yes. It wasn't on the other side of the building. No. It wasn't. It was in an alley. It was dark. Yeah. It was darker than the other side of the building, right? Yes. There was only one light bulb in the alley. Yes. That light bulb was not as bright as it was on the other side of the alley. Right? And the point I'm trying to have her think about something other than this dark alley while not losing my jury, while making sure the jury understands that the lighting in this particular location is important. So here you're doing two things. One, you're taking the witness away from the incident so that the witness isn't thinking about the incident only or the location. But two, you're still signaling to the jury, this location is important, the lighting is important, because this is a misidentification case. Don't use words that are ambiguous. The word hurt is the easiest example of how you can get slammed if you ask a witness, well, look, Kobe didn't hurt you, did he? You're gonna get a 5-minute response as to all of the non-physical ways that Kobe hurt the complainant. He hurt her psychologically, he hurt her ability to work, hurt her ability to go to basketball games, hurt her ability to have conversations about any sports in general, whatever the psychological injuries are, those are gonna come out if you use ambiguous words like, he didn't hurt you. So instead, make sure that when you're cross-examining a witness that you know is a crier, use words that are specific. He didn't punch you. He didn't kick you. He didn't slap you. He didn't choke you, right? These are specific things other than he didn't hurt you. This is, for whatever reason, the misperceptions that I've seen commonly are, well, you got a crying witness, got to offer her tissues from minute number one, right? You got to say, can I get you a box of tissues? That signals to your fact finder that the witness has a legitimate reason to be crying. We're all, most of us, are good people, right? And most of us legitimately don't want to beat up on witnesses for no reason, right? But sometimes we have to. And when we have to, we can't signal to the fact finder that this witness is crying for a legitimate, or she should be crying because this incident was so traumatic that it's impossible to get through without crying. You have to use other techniques other than just handing the witness a box of tissues, which is for whatever reason, I've seen everybody do, many people do this. Another thing I've seen is when the witness is crying at the end of a direct, because some of these prosecutors, this is all they do are sex cases. They are specifically trained to handle sex cases. So they elicit the emotional response at the end of the direct to throw off your cross. So the tears started flowing at the end, and they just sit down and say, have at it. They do that purposefully, right? And one of the instincts is to say, Judge, can we take a 5-minute break? Can we give this witness a break? Again, thereby signaling to your fact finder that the witness is supposed to be crying, that this is justified. Do not do that. Use the techniques that we just discussed. The only exception is if the witness is crying so hysterically that you can't hear her, that no one can understand what the witness is saying. And even then, I caution you, try to use other techniques first. Use unemotional, unimportant aspects, the date, the specific date, the specific address, the distances. Use different unimportant, if the jury doesn't hear these things, oh well, but it slows the crying down. I would not encourage you to take a break unless it is impossible to hear what the witness is saying. And then you take a short break and get right back into your cross-examination. But that is the exception. That is not the rule. Another common technique that I've seen that usually fails is when you say things like, just answer the question yes or no, right? First of all, it makes you look like a dick. And so it's just generally not a good idea. But also, it signals to your fact finder that you're being unfair, right? Because the fact finder is thinking, well, what if the question doesn't call for a yes or no? What if it needs to be explained? So you need to control your witness by asking short, leading questions, one fact per question. That's how you elicit a yes or no response, not by telling the witness, say yes or just say yes or no. Another technique that I've seen at the beginning of a cross-examination that doesn't work is I'm going to ask you a series of questions, all of which are going to be yes or no. So can we agree that your answers are going to be yes or no? Again, it comes across as unfair because you're asking the witness to agree to something. They have no idea what you're going to ask them. And it signals to your fact finder that you're trying to pull a fast one by forcing the witness to agree to answer yes or no when he or she doesn't know if the questions call for a yes or no response. Instead, control your witness by using the techniques that we just discussed, not by trying to make a deal with the witness from day one, a witness that's antagonistic in the first place. And last but not least, please do not ask the judge for help. Judge, just tell the witness to answer yes or no, please. Can you instruct the witness to answer my questions? It shows that you are not in control of the courtroom. You're not in control of this particular witness. Juries want to know who's in control of the courtroom. Who's the person they should look to when there's something questionable occurring? I've seen, if you do it right and objections start coming, I've seen jurors start looking at defense counsel like, what's about to happen, right? Because they trust you more than they trust anybody else. But the moment you start asking the judge for help, you have lost control. And even more practically, the judge is probably going to tell you no, right? So not only have you lost control, now you look like you have no idea what you're doing because the judge just said in front of the witness, the judge just said in front of the jury, counsel asking that question, right? So you've lost credibility in front of your fact finder. The runaway complainant is especially early in my career, but it's still a fear of mine now. But early in my career, I was really nervous because I had witnesses that just wouldn't stop talking. You do what you're taught. You ask the leading question. It's one fact per question. And the witness insists on running off and answering something that you didn't say, you didn't even ask. You went to the 14th Street Lounge. We went to the club. It was about 5 o'clock. When we got to the club, the first thing we did, I ordered water because I really didn't want to drink very much. And so I ordered a water, also ordered wings. And then my friends were drinking. I wasn't drinking because I really don't drink. They ordered me a drink, but I just said, I'm going to babysit all night. I'm going to act like I'm sipping. Okay. You went to the 14th Street Lounge. There you're asking the exact same question, slower. And what you're signaling to the fact finder is this witness didn't answer my question, so let me just make sure she heard it. The witness rambles again, on and on and on and on and on and on. Ask it slower. You went to the 14th Street Lounge. Right? Slowing down the pace of the questioning is amazingly productive because witnesses then say, maybe I should answer this question before I keep looking like a jerk. Ask the same questions and repeat it if it doesn't work. So now your witness is rambling. I got there, I didn't want to drink, I had water, I was babysitting. You went to the 14th Street Lounge. Blah, 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 blah. You didn't go to the 14th Street Lounge. Oh, yeah, I went, right? So asking the same question in reverse oftentimes focuses this runaway witness. Let me answer the question before it comes across as I'm lying about whether I even went to the 14th Street Lounge. Using formal titles is another way to signal to your fact finder, this is important, this witness is being a jerk and running away. You went to the 14th Street Lounge. Blah, 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 blah. Ms. Downs, you went to the 14th Street Lounge. That Ms. Downs, whatever the formal title is, oftentimes slows the witness down. All right, this is important. Maybe I should answer the question. As an aside, this really works with expert witnesses because experts are notoriously running off at the mouth. And you can slow them down. Doctor, The answer, or whatever your question is, but use the formal titles. Shorten your question. Yet again, you've got the witness running off at the mouth. You went to the 14th Street Lounge. Womp, 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 womp. You went to the 14th Street Lounge. Blah, 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 blah. You went. Shorten the question. By shortening the question, oftentimes the witness will just answer it because now the question is so short, they need to just get to the point. This works, but it can. I'm going to be candid. It's rude, and you really need permission from your fact finder before you do it. But bizarrely enough, it works, right? So your witness is just running off, and without saying anything, you just stop. Put your hand up like this. Bizarrely enough, it works. Witnesses will stop in their tracks. The problem is, it really is rude. So you need permission. The witness has to be such a jerk, rambling so much that it's clear to everybody in the room that the witness is not answering your question. That's the only time you have permission to raise your hand and say, It actually, when I know we're not talking about child witnesses, but at some point you will. It really works with child witnesses as well. But again, I would be a bit less cautious with child witnesses. I'd be more cautious with adults. But either way, this works. Just be careful when you're doing it. This is another one that I've used. But you again have to have permission. Your witness, it happened in a case, my very first sex abuse case. Witness was just running off, wouldn't answer the questions. And so while the witness, I refuse to just interrupt the witness because I'm already a male. The witness is a small woman. I'm already fairly aggressive anyway. So I don't want to come across as too aggressive and telling the witness to stop. So I just took a seat, let the witness talk, and then it signals, oh, this witness is just rambling. And when the witness finishes, take your time getting up and ask your next question. Or ask the question over again, actually. That, again, is in line with the hand where it works, but only use it sparingly. Don't make this your default. Don't make this question number one, your witness runs off at the mouth and you take a seat. Don't do that. This witness has to have been doing it for 5, 6, 7 chapters of cross-examination. Then you get into advanced or sort of aggressive techniques like taking a seat. A bit less confrontational is, my question was, you went to the 14th Street Lounge. Or blah, 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 blah. So that's a yes. You went to the 14th Street Lounge. That's a yes signals maybe I should answer that question, yes or no. But it's not you telling the witness, you must answer the question, yes or no. Instead, you're showing the fact finder. This is it. In conclusion, hopefully at the end of your cross-examination, your client is running out of the courthouse like Willie Dynamite, one of my, again, favorite movies. But cross-examination of a complaining witness, it can be scary. I will admit that it is one of the scariest things for me. The only thing scarier than cross-examining an adult complainant for me is cross-examining a child complainant. Nothing else is scarier. So we just went over a lot of different techniques, a few different motions, investigative tactics, reading the jury instructions, but candidly, there are really only 3 rules to cross-examination. And these are not the 3 rules I mentioned earlier. I'm actually serious about these 3 rules. Stick to the basics. The basics work. The best trial lawyers I have ever seen don't deviate from the basics. Basics like using the chapter method of cross-examination. It works in every case. No need to deviate. Number 2, only ask leading questions that will establish each chapter. I've seen lots of lectures on advanced cross-examination techniques, asking open-ended questions to bait the witness, all of which there's a time and place for. But the the most successful trial lawyers I have ever seen stick to the basics. 99.9% of the questions are leading. These open-ended questions, sure, there's a time and place for them. Very, very seldomly. So stick to the basics. And last but not least, ask one new fact per question. If you stick to the basics, regardless as to who you're cross-examining, your client will run out of the courtroom like Willie Dynamite. Thanks for having me.